let's get started. Self-determination is our chapter. And we begin by looking at some of the material in the textbook. And your textbook mentions that the self-determination era began essentially when the termination era ended, right? And the hard part about that is we know when termination began. Remember the name of the law? Was it HCR 108? House Concurrent Resolution 108. That was the piece of legislation that you would have read about in Chapter 9, in which the Congress made it possible for tribes to remove themselves from the tyranny of the federal government. Okay? So the thing to remember about HCR 108, that was basically the termination guidelines, termination authority. That was different from PL 83-280 or just PL 280. Okay, that was also in the same year. So PL 280 and HCR 108 are kind of related in that sense. And I'm stepping back from this slide, obviously, but what was going on in the United States, particularly the United States government in 1953? What do your historians usually call that era between the start of the Cold War and, I don't know, the mid to late 50s? It was the early days of the Cold War, and it was also the period of McCarthyism, right? And as you might remember, Senator Joe McCarthy of Wisconsin, right, was on a one-man mission to clear the country of communists or supposed communists, and it was a very tense time, also tense because of the Cold War and other things happening. You know, the Korean War was still in progress, and other facets of the Cold War were coming out. But it was also a time when the United States government switched from what your textbook author refers to as a separatist period, sort of a separatist period within American Indian policy, to another assimilationist period in policy. So we covered the termination era last time, and in the termination era, one of the more important facets of termination was the creation in 1946, right after World War II, of the Indian Claims Commission. The Indian Claims Commission, you recall what the Indian Claims Commission was tasked to do? I called it a tribunal last time, but the Indian Claims Commission was it was considered to be and intended to be a temporary court that basically took the role of the United States Court of Claims. So if you want to sue the United States government, you have to go through something called the United States Court of Claims. And tribes could do that up until, but it's very difficult to do that. It's very difficult to get a case even accepted, because what the United States does in the U.S. Court of Claims is it waives its sovereignty. You have to have a good case for the United States to waive its sovereignty for class action suit of some sort. So this is a interesting period. In order to sort of clean house, in 1946, the Indian Claims Commission is created to just hear claims against the government by Indian tribes. with the idea, and I think I talked about this last time, just trying to jog your memory, with the idea of the United States clearing its reputation or clearing the air with Indian tribes. And do you remember why we classify that as part of the termination era? And y'all can chime in online anytime. So why was the Indian Claims Commission considered part of the termination era? Sort of the beginning part of it. Because, I'll answer it, I guess, all right? Because the one sort of caveat that the tribes, were up against was they had to bring everything they had, and when the Indian Claims Commission would hear it in a court, just like a regular trial court, then if they won and received an award of damages of some sort, then the case would be closed forever and no further actions could be brought against the government from the tribe. Now, this sounds okay, except for one problem. And if you look at tribunals for indigenous peoples around the world, and there are some like the Waitangi Tribunal in New Zealand for the Maori, currently in Australia, they're going through another set. And in Canada, all of the Anglo-speaking, colonized countries of the world have similar sorts of procedures. But in the United States, our procedure was referred to as an adversarial procedure. So what would happen was, and one other kind of unfair part of this was that, do you recall from the reading? I'm going to assume you've read through chapter 9.
Wasn't it a really slow process?
It was a very slow process, yes. And there was a timer on it. So the Claims Commission was created in 46, and it was only supposed to, the tribes could bring suit within 5 years. So from 46 to 51, they had to, if they were going to open a claim against the government, they had to get everything ready and file within 5 years. So that's the first sort of hurdle. And another part of that was the government had to approve of initially the government was going to create a commission to sort of help the tribes do the research and all this, but then that never happened. So that fell through with the clock ticking. And so the tribes, if they were going to bring suit, had to hire them themselves, which is difficult to do when your tribal government's just very infantile and just getting started. But the other problem was that the federal guideline in the Indian Claims Commission required that the lawyers or the counsel for the tribe, the federal government had to approve of the pay for the counsel. And there was a cap put on it at 10%. So whatever the award would be, lawyers could only take up to 10%. All right? So what does that do to a tribe's case?
It limits the amount of lawyers that want to take it for the cap.
Yeah, it would severely curtail any sort of claim to something that's going to be pretty big. It's going to have to be really big in order to for anybody to take it on. Unless, especially for a really good law firm, right?
Yeah.
If you want a really good law firm to take it, they're going to have to make some money on it. And 10% on, and that's just, that's if they win. Nothing said they were going to win. Because this is an adversarial procedure. And the tribe might be able to hire lawyers, but guess what? The federal side, the defendant, also is going to have lawyers, and they're going to attack every single move that the representatives of the tribes put forward. So they're going to try to disprove or dispel any claim and any evidence of claims that the tribe brings against the government. So kind of interesting there. So really only the most obvious, perhaps, blatant, severe types of claims would ever be brought to the Indian Claims Commission. And again, if the tribe brought the suit and lost, who could they appeal to? Not really anybody. It's just that's it. So it was very much of a gamble for tribes to even attempt this. There had to be a lot of good evidence. But anyway, nevertheless, there were a lot of tribes that did file claims, and what you saw was the process, as Sarah said, the process was so slow that Congress had to continually extend the life of the Indian Claims Commission until eventually it closed down in 1978. Right? So it was a long period of time. So keep that in mind. The idea of the Indian Claims Commission was to get rid of any loose, to tie up the loose ends with any tribe. And then, of course, termination was an issue. Termination was the idea that it wasn't an elimination. It's hard to get past this, at least for me. Termination did not involve the elimination of an Indian tribe. Okay, it eliminated what termination meant was it was ending the federal government's role, or basically it's ending their recognition, tribal recognition. They would no longer be a federally recognized tribe. That didn't mean that the state couldn't recognize them. Even up to the recent, the last 5 years, there have been a number of tribes. Well, I should say, 5 years, I guess, 2017, from when we are here. In the last few days, or the last year of President Obama's administration, there were a number of tribes who were picked up and federally recognized. A lot of groups in Virginia, for example. So federal recognition can come, and it can, in the termination days, it could go. Now, you've read about the Menominee example, and in that case, you have, and also, there are a few other examples of tribes who had their relationship with the federal government terminated. But what's the lesson from termination? I guess, did termination really resolve what the United States Congress wanted it to resolve? Well, the answer in this class is usually no, right? That's typically been the case. And it really didn't. In fact, this was one of those many examples that we've talked about, and maybe some we haven't talked about, many examples in United States Indian policy and Indian lawmaking in which the federal government tried to do something to clear things up, whether to assimilate, and usually it involves assimilation or rather than recognizing sovereignty. So the termination era was very much an assimilation period. But every time the government tries to do something, it usually backfires and usually creates a bigger problem. And so, this Indian Court of Claims was an attempt to tie up loose ends when in fact it just kind of opened up another can of worms. So, and not only that, but you see some examples where, in the case of the Lakota in 1980, in the Indian Claims Commission case that they brought against against the government. Oh, there was one other caveat I did fail to mention. What did the government say in the Indian Claims Commission when it was set up? What could tribes receive? Sorry, I'm kind of swimming all over the place here now. Remember that the rule in the Indian Claims Commission was tribes could only sue for damages. Okay? They could only receive monetary equivalent or damages and equity. They could not receive land. There was going to be no returning of land if it were taken, and there are a lot of language like there's a lot of language used like, well, perhaps a tribe would have a claim if in a cession of land in a treaty, let's say in the 1850s, and the compensation for that land in the treaty was, 10 cents an acre, when at the time in the same area, the United States allowed settlers to purchase land at $1.25 an acre, which was actually a common amount, $1.25 an acre, but that's like $18.50, $18.60. So it's still pretty cheap, but a lot of people didn't have the cash. And in the case, though, there are several good examples of this and geography theses on this. A tribe would cede land to the government because the government wanted it, and typically that tribe would be removed to Indian Territory somewhere, Kansas, and that land, the compensation for the land, to clear the Indian title was often something like, 8 cents an acre equivalent. That's what the tribal attorneys had to find. They had to identify how much money was provided, and in the treaty, that the terms of the cession that was usually given. Sometimes the money wasn't even given. Sometimes the treaty was signed and the agreement was signed, and the tribe never even received the compensation. Other times, if it was like 8 cents an acre and the going price of land of the same quality at that time was $1.25 an acre or more, then there was a problem, right? So, and if you had an issue like that, then you're saying, okay, we got stiffed by the federal government, and y'all owe us this much in $1854, okay? And so the difference is this is what we should have received, and then let's calculate compound interest over time, okay? So if you really want to talk about damages, you've got, over 100 years of compound interest on this large amount, okay? So that's a pretty good argument. However, the federal government comes back, and this is something I didn't discuss last time, so I'm trying to cover it. The federal government comes back and says, all right, any award that we make an Indian tribe is going to be minus gratuitous offsets, the term. Your textbook refers to it just as offsets. If you look it up, the legal term of offset comes from another legal term called set off. All right, and what that means is the expense of the federal government in bringing and defending itself, basically, and at least in this case, that's what that means. So essentially, even if a tribe wins a case, they still have to pay attorney's fees. They still have to pay court costs. All right, they're paying for the suit. Now, I don't really like that. If you sue somebody and if they lose, right, they pay the court costs usually, not in this case. So that was another hindrance, in terms of lawyers' fees and then the award. And not only were the offsets based on the court costs and the federal lawyers' fees, but it was also if there was anything since that session that the tribe may have received, that was counted against the award too. So the federal government did everything they could to reduce the award. So in your textbook, the author does a good job of sort of summarizing what happened. Basically, the Indian Claims Commission was set up like, hey, everybody come to the table and let's make peace, let's make amends and fix this, poor reputation we have for ignoring treaties, breaking treaties, and let's fix all that. And what happens is they fight like crazy. The federal government fights the tribes like crazy. So that's the Indian Claims Commission. It's a very very interesting part of the termination era. So termination also involves House Concurrent Resolution 108, all right, which allows for the termination of Indian tribes, basically the disowning of tribes. It's sort of like if the tribe is if the government is the great father, and there's a fantastic history of American Indians written by a Catholic priest by the name of Paul Prucha, and the title of his great big opus is called The Great Father, all right? And because that's the sort of the analogy, or that's what the government often calls itself. That's how the government was often portrayed to the tribes, the Great Father. So say the Great Father has this obligation to care for the ward, or these children, these Indian tribes, and he's taken it upon himself to write treaties and make agreements and institute this idea of the trust obligation. Okay, and now after so long, the trust obligation becomes, you've been here long enough. It's time to leave the nest. That's kind of what the termination philosophy was. That we've been dealing with, and a lot of the tribes who were terminated, they were relatively small tribes that maybe didn't participate in organizing their government during the Indian Reorganization Act, the Wheeler-Howard Act. So they were considered sort of marginal, and some of them were considered to be not needing federal assistance or not needing supervision by the Great Father. But in a sense, what the Great Father here is doing is he's disowning these children, saying, okay, go away. You're not my problem anymore. Right? So, all right. And then, but the most problematic facet of termination was, of course, PL 280, Public Law 280. And the problem with that is it's still around. It's still with us. PL 280 just didn't go away. It was not repealed or anything. And I don't know if I explained it this way last time, but essentially the states really were not interested in taking responsibility for basically crime on Indian land. So what PL 280 did was it assigned certain states authority. Basically, they're going to take over the federal role over Indian country within their states, and not all Indian country. It was basically aimed at tribes. So certain tribes were going to be subjected to state authority rather than federal authority. This is why certain tribes, in the PL 280 states are exempt. They're not part of PL 280, which makes everything very complicated, right? Like, and initially it was what, 5 states, and then Alaska in 1958, and then several other states joined in, or several other states became sort of partial to PL 280 states. So it's very complicated. Thank goodness Oklahoma never did. So Oklahoma doesn't have these issues with, when something happens, you have to always consider, well, is this a PL 280 state? Is this reservation subjected to PL 280 in that state? All those are important. Unfortunately, the Supreme Court will typically recognize anything that's not specifically covered by PL 280 state for taking over. Anyway, states really didn't like it. Tribes certainly didn't like it. Federal government, again, trying to make things cleaner and easier, just made things messier and more complicated. So, termination. What ended termination? That's the question. And this is why I have a little bit of criticism for Chapter 10, is because it seems to me that the first argument is, well, what really was the beginning of self-determination was Williams versus Lee in 1959, court case, right? And I think this is a stretch. This is the first stretch in the chapter. But I'm not here to criticize the textbook. And it's just, I think I understand what's going on. But so the question, Williams versus Lee, y'all read that? Yeah, of course you read that. The question here is basically, does a state have authority to extend its jurisdiction into Indian country when there is a non-Indian and an Indian, well, I didn't word that very well. Basically, does it have jurisdiction when there's a civil dispute between a non-Indian and an Indian on Indian country, in Indian country? Okay, and I'm using those terms as shorthand. Sorry. The question is, is that the case? And to make things worse or more complicated, in this case, we're talking about Arizona, the state of Arizona, and the Navajo Nation, right? And even though Arizona wasn't PL 280, it was one of the later PL 280 states. It had not specifically taken authority over business transactions between, on the reservation, is the way I understand it. So the Supreme Court of the United States, SCOTUS, says no. In that case, because Arizona didn't specifically take that part of its, didn't claim that part of its jurisdiction as part of its responsibilities, then we don't have a problem, or there is an issue, and that is that Arizona can't extend its authority over the Indian tribe unless the Indian tribe wants it to or allows it. Okay, in this case, it didn't allow it. So what this brings up is the idea of what's called an infringement test. Infringement, that simply means, it could mean overreach or sort of trespassing on sovereignty. The state law, in this case, Arizona law, was found to be invalid in Indian country because the tribe wanted to regulate this. The tribe wanted to settle this. And if Arizona decided without authority, without written authority, to just jump in and start changing things and subjecting the parties to state law, then that was considered to be an infringement on tribal sovereignty. The tribe wanted to be able to do that. And so the part of that trust responsibility, one of the most important facets of the trust responsibility of the federal government is to ensure, remember this, to ensure the tribe's ability to govern itself. Okay? They have the right to possess the land until they don't, and until they want to give it up. And they have the right to rule themselves or to govern themselves. And in this case, it's a matter of civil jurisdiction. All right. So what I'm saying is, so the author points to this case and says, all right, well, the Supreme Court for once began to recognize tribal sovereignty, and the state lost, even it was PL2A state. Okay. So anyway, let's go on to the next rationale. And this was 1974. This is a little different. Later on down the line, 25 years later. No, not 25. I can't do my math today. 15 years later. So 15 years later, 1974, good year, or interesting year, we have and this case is a little bit easier to understand, but it's significant. But this is well into the self-determination era. So I'm not sure why he brings this up, your author. So you remember what the case was here, Morton versus Moncari? It involved employment at the Bureau of Indian Affairs. And since the days of John Collier, and even before that, the Indian Office had preferentially hired Native American people to work in it. Okay? And today, if you go to any area office of the Bureau of Indian Affairs or the Indian Health Service or anything, most of the people working there are Native Americans, right? And that's considered to be, that was a goal of the government to not necessarily, it wasn't a make work program for Indian people. It was, the purpose was, well, these federal agencies are set up to serve a specific group of people in the United States that's defined by the Constitution. No other group is really defined by the Constitution, except maybe slaves. But in this case, Native American people are the reason these agencies even exist. So they should work there because, why? Because it would be a lot more, I think it's just common sense, right? If this government agency has the charge to oversee things happening between the federal government and the tribal nations, then it would probably make sense for Native people to be the folks doing that, okay? And it's just kind of touchy, but the tribes, of course, would probably have more, interaction or ability to interact with people who are also affected by this agency, right? Well, anyway, what happened was after self-determination got going, up to about 1968 or so, the composition of the Bureau of Indian Affairs, I think the Native American population was still, there's a quote in there, I think, isn't there? It was still less than 50%, right? Something like that. So during the 60s and the 70s, especially after 1970, the hiring process began to be like this, that the non-Native people who worked in the Bureau of Indian Affairs they were encouraged to retire, and Native people coming up through the ranks were often selected as, they were the ones who were getting the promotions. When someone who was, if there were, say, 4 or 5 people who were up for promotion, If you were non-native, then you're probably not going to get that promotion. So this brought basically a class action suit by the non-native employees of the Bureau of Indian Affairs. They were saying basically this is a case of reverse discrimination, and we're more qualified, and this is a meritocracy, and there's no reason why there should be kind of an affirmative action approach to hiring here. All right, if somebody's more qualified, clearly more qualified than someone else, then they should get the job. So that was the argument. And how did it come out? That argument didn't hold up, as you recall. That argument did not hold up. Why? And an important part of all this is the reason why. And I once heard I don't know who it was in a class probably as an undergraduate when I was at OSU. But I remember a Native American person making a very clear point that American Indians are not like other ethnic minorities in the United States. In fact, I think he said, we're not minority groups, okay? We're nations of people. And he had a very good point. I always wondered about that, but this clears all that up. This case explains that American Indian people, and this is maybe why American Indian folks were not so super excited about the civil rights movement. They had their own movement, the American Indian movement, okay? They separated themselves from the civil rights movement because they did not consider themselves an ethnic minority who were oppressed, right? They were nations of people who were not recognized or their sovereignty was in jeopardy. So the American Indian movement, which was pretty radical, was also, it was one part of the late 1960s, early 1970s. Talk more about AIM. So what happened in this case were that the Bureau of Indian Affairs employees who were members of federally recognized Indian tribes were not in a class of ethnic minorities. And what this, if you look at the discussion on this, you'll see that there are two tests. There's a legal test as to whether or not there is what's called a suspect class. Was this policy within the Bureau of Indian Affairs, this hiring policy, was this something that would fail the tests of whether or not there was a special, what they call a suspect class of people being targeted? In this case, it would be the non-Indians would be suspect class. But that's not it.
And I'm sorry, so they tied the suspect class, or not being part of the suspect class, back to long-standing relationship with the federal government as a nation itself.
Right. Well, okay, it's actually pretty simple once we get to the punchline here, and you'll just say, aha, well, the federal government, as I've said a lot of times, they're not dealing with people, they're dealing with governments, all right? It's a government-to-government relationship. There are a lot of governments, there are a lot of tribal governments, a lot of nations of people, but they're not defined by, at least to the federal government, those nations are not defined by some sort of ancestry, okay? Now you'll say, well, yeah, they are, because the tribe determines citizenship based on blood quantum, right? Based on ancestry. Some tribes stop at a quarter. Some tribes, like the Cherokees, have they'll take anybody as long as you're counting on the roll, and so you can be 564th and still be a tribal citizen. So there are big differences there. That's not what they're arguing. what they're arguing here is that the federal government has a government-to-government relationship. Those people are part of that nation, and that nation is not defined to the federal government by blood quantum. That's their own business, okay? And so that means that, and take an example of this, in some tribes back in the late 1800s, like in Indian Territory, like the Choctaw Nation, you know the town McAllister, Oklahoma. What's it known for? Prison. Yeah, of course these days. Right, Big Mac. But originally it was known for its coal mines. So there are all these little coal mining communities around McAllister, Oklahoma, and Pittsburgh County without an H. Okay, so Pittsburgh County and McAllister was chock full of coal. All right, that's a good one. The railroads built through McAllister, and the individual who got pretty wealthy off of the coal mines originally was a fellow by the name of J.J. McAllister. All right? J.J. McAllister was an intermarried white. He didn't have any Indian blood. He married a Choctaw woman, and I think later divorced. But before he divorced, he got citizenship. He was officially Choctaw, a member of the Choctaw Nation. So there's an example of somebody who would be a member of a tribe without being racially American Indian, right? So he would still be treated as an American Indian by the federal government. So this is what the line is, basically, is that tribes are political entities, and the relationship between the United States federal government and the tribes is a political one, not a racial one. All right? So there was, whoever wrote that opinion, I don't know if it was a Chief Justice or not, whoever wrote that opinion actually kind of got a little snarky and said, this is not even a question of race. Race doesn't even have anything to do with this. If you're a member of a tribe, then we want those tribes to be part of this, this agency. So, tribal membership does not imply racial classification. Members of federally recognized tribes are politically defined, not racially defined members of the United States or citizens of the United States. Now that ought to be pretty clear by now, because the fact that Native American tribes are mentioned 2 times overtly and another time sort of implied in the Constitution. They are recognized and they are absolutely separated from citizens of the United States. This is why the relationship between American Indian tribal governments and the United States has always been subject to congressional plenary power. It goes back and forth. There's no guarantee. There's no solid constitution for American Indians. It's piecemeal and it's contested. So everything kind of goes back to what the power that Congress has. All right. Well, we probably beat that horse to death way too long. But any questions on that? Now, the interesting thing here is that I say, okay, 1974 is, that's an interesting year. That's the year that I'm not a crook. Yeah. President Richard Nixon, left office, resigned, the only president to ever resign. He resigned over Watergate. And he generally has an awful reputation. Now, recent history is probably going to help him out a lot, all right? Richard Nixon is no longer the devil, all right, to many people on the left and the center, okay, including myself. But Richard Nixon is actually I think, very underrated when you look at his foreign policy and his domestic policy. everybody kind of knows about his foreign policy. You know, he's the one who opened up China to trade with the United States, and now China's the work what do they call it, the workshop of the world, and they've completely transformed their society. And now they're a rival, maybe a great power rival with the United States. But more than it's also allowed us to have really cheap stuff at Walmart. All right. Well, anyway, so Richard Nixon had a great foreign policy, and the thing that my dad always said was, because I have a brother who's about 10 years older than me. What my dad always said about Richard Nixon was, "Thank God he ended the Vietnam War." Right? If it weren't for Nixon, we might still be. That's what he used to say. So ended Vietnam. Opened up relations with China, and at home, and as Sarah knows because she's taken my conservation course, Richard Nixon was probably, unless, I don't know, how, was it Clinton that came up with the phrase, Bill Clinton came up with the phrase, y'all wouldn't know this, maybe, you're young, but Bill Clinton said this was the, no, it was Al Gore. It was Al Gore, wasn't it? Al Gore said he was going to be the environmental president, right?
Yeah.
Isn't that right? When he was running. And
grew the beard and everything.
Yeah, but if you go back, Theodore Roosevelt was certainly an environmental president. He was unlike Republicans in that he grew the government and was very much about getting federal lands, removing federal lands from access to. In other words, he wouldn't allow the public domain to go out to private hands anymore. So he started making these, reserves and parks and so forth. So most people will agree that Teddy Roosevelt was an environmental president. But I would say by far Nixon was number two. And probably what Nixon did and the legislation that was passed during his second term and right after his second term, was just signed off by Gerald Ford. Those were big government things that he did. So Nixon is historically seen to be a moderate. He was the last Republican moderate, and he was actually a very moderate Republican in that he started the Environmental Protection Agency, EPA. He passed the Environmental Protection Act, Clean Water Act. Actually, it was an amendment to the the Clean Water Act and an amendment to the Clean Air Act that was really significant. And then there's about a dozen more or so agencies that he created that were environmental-oriented agencies. So it's pretty amazing. When it comes to Indian affairs, there is no president who has more accolades for changing Indian policy for the better, at least from a tribal perspective. Okay, so Richard Nixon did many, many things, which makes me wonder, why isn't he mentioned in the chapter on self-determination? Because he's the one who brought the whole thing out and called it self-determination. Richard Nixon, his presidency was elected in '68, so he's entered office in early 1969. His legislative agenda with Native American tribes and Indian affairs mostly began in 1970. And these are just some quotes from something pulled out from that long address that you have in a PDF now. But of course, Nixon was reelected in 1972. We'll talk about that, but reelected in 1972 and then left office in 1974 in duress. But let's talk about the context of Nixon's term. Nixon came into, and yeah, he was influenced certainly by his football coach, but he was also entering office during a very volatile time in American history, where, you know, he came in 1960, or he was elected in 1968, which was one of the most tumultuous years in recent history in the United States. He also came in when the American Indian movement was really building up a lot of steam, and there was a pretty well-known event in San Francisco Bay that involved the occupation of Alcatraz Island. If you know, Alcatraz is the old prison island that was taken over and declared Indian country. That's a kind of a different story. But the other issue that was very, very serious and where people got killed was at Wounded Knee, the original Wounded Knee location, and they called it Wounded Knee 2. But this, it was a BIA facility that was taken over and held by armed individuals for a while, and the FBI basically had a standoff with them. The FBI standoffs are not fun, as you know. And anyway, there was an FBI agent that wound up getting killed, actually. So there were things going on related to Indian identity and that sort of thing. But I'm also going to, well, let me also tell you about this. I don't think I put it in a slide. Yeah, I didn't. Nixon was very much assisted by, again, he was a moderate. He went across the aisle, which is not something that happens much anymore. And there was a senator from Washington State who was a Democrat who Nixon worked with on Indian policy. And so this senator hired an individual who was from Montana, and he became, and I'll try to maybe put some stuff in here later, but he became very proactive in developing this whole self-determination policy. So there are some, the senator was a guy by the name of Jackson from Washington. He died in like 1989 or something. Anyway, he's not around anymore, but so that was, that has something to do with it. But let's look at the major pieces of legislation, and we can get into a review of some sort. So this one didn't really, this piece of legislation, the Indian Civil Rights Act, was passed in '68, so it wasn't his. This was really the work of the Johnson administration, LBJ, and Congress. And this is interesting because, has anybody ever heard of the Indian Civil Rights Act? Did you read about it? Briefly, maybe? Just in passing, sort of? Again, I'm not sure exactly. Maybe you'll cover it later in the book. But the Indian Civil Rights Act, it sounds like a law or federal statute to give Native American people the same civil rights as everyone else, right? But that's not what it is, really. It kind of has a deceptive name. What it was it was filling in the gaps. It attempted to fill in the gaps where the Bill of Rights ignored tribal nations, people who belonged to tribes, Native people. So anyway, and it wasn't necessarily all good. It didn't have all good outcomes necessarily. Okay. So it was an act of Congress called the Indian Civil Rights Act, or the ICRA, and what it attempted to do was to bring the rights under the Bill of Rights to Indian people through their tribal governments, all right? So tribal governments weren't necessarily held to the United States Constitution, or at least the Bill of Rights, right? So this was a problem. At least it was, and we'll talk about Talton versus Mays at a later date when we get into things like criminal justice. It actually involves the Cherokee Nation. It's pretty interesting. The tribal governments, had been, they had been, I don't want to say, I guess I said overlooked, but they were skipped over. They were intentionally left out of the Constitution, or separated within the Constitution, I should say. And what that did was it didn't provide federal protections of individual rights at the tribal level. So, if a state passes a law that doesn't conform to United States constitutional standards, then because of the supremacy clause of the Constitution, states can't break. They can't violate the basic rights of the provided in the Constitution. There's the Voting Rights Act, for example, had to come along to fix that for the states. But there were so this is kind of coming out of the same. This is also an LBJ based program, just like the Voting Rights Act of 1964, right? And desegregation legislation, followed by Brown versus Board of Education. Anyway, different class. But the tribes were subjected to this, or tribal government was subjected to this federal statute with the intention of protecting individual Indian people from their own governments. Okay. So, what do you think about that? Is that part of this? Is that self-determination, or is that maybe federal overreach? It's a hard answer. Hard question. The Talton versus Mays case involved a case in which it was a capital murder case, and the Cherokee Nation sentenced a man to death, sentenced a tribal member to death. And to do that, it required a jury of so many people at the time in the United States. So you couldn't just sentence somebody to death with a jury of 3 or something. And the Cherokee Nation had basically done this. And this guy, who was kind of like the McGirt decision, he appealed to the federal government, and what happened was the federal government stepped in and said, look, this is a problem in the Cherokee Nation doesn't adhere to the standards of the Fifth Amendment of cruel and unusual punishment and a jury of, a large enough jury of your peers. So this is what, this is kind of it's a case that goes way back, but the Indian Civil Rights Act was intended to extend those protections against tribal governments acting upon American Indian citizens. But I think you can say, you make a case that this is also kind of an intrusion by the federal government into tribal sovereignty again. It's not as severe as the Major Crimes Act, but it does, sort of say, okay, tribal governments, you have to have a certain conformity to our standards. So anyway, it came in as an amendment to PL 280, right? To require tribal consent to allow state jurisdiction and allow the PL 280 states to retrocede their jurisdiction from over Indian country. Don't worry so much about those details. We'll talk more about that in a different chapter. But the Indian Civil Rights Act came out in 1968 before Nixon. I would argue that this is another example of, federal government sort of demanding conformity, kind of like under the Indian Reorganization Act. Remember the significance of the constitutions there? What did the tribal constitutions, how were they approved? They had to be approved by the Department of the Interior, and they had to have certain standards. So again, the federal government telling the Indian tribes how to do things. All right, this is Nixon's primary legislation that we're talking about. Even though it was signed into law in 1975 after he had left office, it was signed into, it was in the works for years, and Gerald Ford signed it into law. Sorry. We have two of these. All right, so the formal name is the Indian Self-Determination and Education Assistance Act. It's often referred to as 93-638, PL 93-638. Remember that number, 638. That's an important one. So this is the law that really launched a policy named the self-determination policy. Just to jump forward a little bit, when Ronald Reagan took office in 1981, his Indian policy would pretty much mirror what Nixon had. He also recognized self-determination. Of course, Reagan was one who wanted to get the federal government off everybody's back. So, and it's kind of interesting during the interim between Nixon and Reagan. It's called Jimmy Carter, the one term of Jimmy Carter. And I'm not real familiar with Jimmy Carter's Indian policies, but I know that it was the federal government again, kind of coming in somewhat heavy-handed. Nothing really there wasn't a lot going on in Indian country in terms of economic development and that sort of thing between about 1977, 76, or 77 and 1981 during Carter's administration. But then things changed when Reagan came into office. A lot of the red tape that tribes had been used to working through was eliminated. So, and that's when you have the beginnings of things like gaming, tobacco sales, the utilization of sovereignty as an economic development strategy, right? Primarily with gaming, which is another topic. All right, so in the case of the Indian Self-Determination and Education Assistance Act, 1975, this transferred federal services under the federal the trust obligation directly to the tribes who wanted to take them over. So they, if the tribe could demonstrate that they had, the infrastructure and the personnel to take over these federal government project or programs, then they could do so and just receive the money directly, and therefore do things a lot more efficiently and let the money, go farther. So the Cherokee Nation under Wilma Mankiller. Wilma Mankiller was elected, I think, in 1987, but she really turned this up, started taking over hospitals and clinics in the Cherokee Nation. But now, the Indian Health Service is, in the Indian Health Service, you have clinics and you have hospitals, and those are now run mostly by the different tribes with Indian Health Service funding plus tribal funding now. So anyway, the idea was that this was intended to reduce the power of Bureau of Indian Affairs administration over the lives of Indians and get the federal government out of tribal operations as much as possible. So a conservative reduction of federal government's role in people's lives, an example of devolution of power from the federal to the tribal government. That's a new concept maybe. Now, if you've had political geography or cultural geography or world regional geography, some of you have, devolution, remember what that meant? Sarah, you probably remember that. Remember that? In political geography. Okay. Devolution is the act of a central government moving resources to the regional governments, moving responsibility and even authority to the regional governments. That's probably not the best term for this because the United States is a federal system. In unitary government systems where there's just one central government and not state governments, it's not like dual sovereignty, or in the case of the United States, triple sovereignty, okay, for some people. It's probably not the best word, but essentially it's moving resources out of Washington, D.C. to where they are needed and theoretically would be more efficiently utilized. It had a lot of importance to tribes initially through taking over some of the work of the Department of the Interior. So now tribes generally have they have different agencies. They have different tribal agencies that mirror the role of different federal agencies they've taken over. So they'll have, I go to Pawnee every now and then, and if you drive around Pawnee and see all the tribal offices, there's the Pawnee Department of Environmental Quality. So they've taken over responsibility for water resources and that sort of thing within Pawnee land or on Pawnee land in areas that are affected that affect Pawnee land. There are in addition to natural resources, you have cultural resources, and we'll get into that perhaps. I don't think I'm not going to test you over it, but we'll maybe mention it here a little bit. So cultural resources, just about any type of regulatory structure that the federal government would be trying to do, the tribes can now do that. I mentioned the hospitals with the IHS and Health Service. So, important thing here about this is the tribes enter into contracts with the federal government. And these contracts are called 638 contracts. Right? 638. So the 638 contracts, you did read about a case in your textbook, and I'm not going to test you over that. I'm not even going to talk about it because it's really long and convoluted, and I couldn't really see the importance of it to that chapter, self-determination. Basically, that case involved tribes doing the work as a subcontractor, or just a contractor, doing the work that the federal government is obligated to do, but the federal government wasn't paying them enough, or the federal government wasn't sending them the money that the federal government owed them. But don't worry about that case for the exam. Anyway, so the federal government transfers appropriations directly to the tribal governments, and that was in itself very much an end of, the termination policy, because once there's this, tribal infrastructure and the promises that the federal government's going to support those operations, those different agencies within the tribe, then, you can't really end that very, very easily. Anyway, so I have another, I'm getting kind of snarky here, but John Collier finally got his way, and because of a Republican administration, okay? Basically, the tribal governments actually began to act like governments, making decisions for their people, in a variety of different ways. Bureau of Indian Education is, strangely, it's within, I believe it's within the Department of the Interior. It runs Native American colleges and schools and transfers money to Indian tribal education. That is a huge amount of money, as you might imagine. But that's just part of this Self-Determination and Education Assistance Act. Questions? Now, another one that came along during the Jimmy Carter administration, this is during the self-determination era, is called the Indian Child Welfare Act, 1978. And it also expanded tribal jurisdiction, okay? But in this case, into family matters. What it did was it allowed tribes to sort of make their own decisions. Up until this time, up until this time, it was pretty common practice for American Indian children in poverty-stricken homes or broken homes, where there's not maybe a parent that was around enough. Social workers would often take the children and maybe if the parents allowed it, put them up for adoption. So it was really common for non-Native people to adopt Native American children and raise them as non-Native people. Okay. Now that it wouldn't break their tribal affiliation, but it would break a cultural affiliation. So this was passed during the Carter administration, obviously. It was an intent to maximize tribal jurisdiction and minimize state jurisdiction, because things like civil matters like adoptions and divorce and marriages, what else? Family law. Okay, family law is generally the purview of the states. So now this is a piece of federal legislation that attempts to allow tribes to sort of take over the role of the state when it comes to family matters. So this is what it did. It created a priority, and you can play devil's advocate about this when I finish. Indian children were then treated differently than any other children in the adoption system, or the what do you call it, the public welfare system. Number one, the priority was given to they should be adopted by members of the extended family. Okay, so, and if that couldn't happen. They were to, the next level would be a tribal member would have priority if an extended family member didn't want to take the child. At the next level is, the children would go into a group home operated by someone in the tribe or by the tribe itself. And only after that, if nobody would adopt them, a Native American of whatever tribal affiliation could adopt the child. But basically, this was trying to prevent placement of orphans or children within the system with non-Indian families. And this was passed down. So it also funded tribal social welfare offices to support these programs. So again, it was moving responsibility and funding from the federal level or from the states to the tribes. Another issue I didn't mention was housing. Up until the 1970s, any assistance with housing was handled through HUD, Housing and Urban Development Department, and now that funding would go directly to the tribes. So tribes, just about every tribe has a housing or a real estate department, as they might call it. What do you think about this? If you're playing devil's advocate, what would you say? Would you say this is a great idea? It may be a personal morality choice. I don't know.
When my daughter's adopted, and I remember reading like this. At the time, I thought it was absurd.
Mm-hmm.
It's like, this is dumb. Because again, I thought at the time I thought race as opposed to non-suspect class.
Yeah.
So I didn't see the extent of it because in California and San Diego, we were surrounded by tribes. So
Mm-hmm.
just at the time, we thought, well, just try and get the child in a good home as opposed to identity or cultural affiliation.
I have a cousin, first cousin, who's full-blood Arapaho, and he was adopted by my aunt. But he wasn't raised in an Arapaho culture, so he didn't know much about it. So and that wasn't good. So, but anyway, one thing I think you might, if you see this, to me it reminds me of the arguments about that certain folks have about same-sex couples adopting children. People say, "Oh, that's horrible. You shouldn't be allowed to do that." Well, number one, that's a morality judgment on your part, on those people's part, and number two, it doesn't do children in the system any good. It only delays children from being placed in a safe home, right? So, to me, it's been criticized, not by me, but it's been criticized as slowing, in keeping children in the system, the welfare system, too long, and not being able to be placed. So,
Professor,
yes.
was it being used by non-Native Americans as kind of this sounds bad, but sort of like a child store or somewhere where they could go and know that they could easily get a child from out of there? Because if it was being used like that, then I would say on its surface it probably was a good idea if it stopped the trafficking or the passing out of children to other people.
Well, I think you're right, and that this has a history of, the poor generally are going to lose their children or give up their children easier than other folks. So, yeah, you've got a point there. And I think that's the justification, the rationale. I wouldn't go so far as child trafficking, though.
I didn't know the terminology to use.
Yeah, and it is something that, and there were a lot of Native kids in orphanages, especially in the first half of the 20th century and earlier, who weren't orphans. They were just in the orphanages because they were often taken
Right.
by Indian office workers, and the government, and placed in schools, and because that was considered to be better for their future. Sometimes Native families, couldn't afford to feed them, and that was maybe a trade-off. But yeah, I recognize your argument there. That's a really good point. All right, so that's about it.